why preferential treatment to a special section of society is not frowned upon. Article 30 is a special right conferred on the religious and linguistic minorities because of their numerical handicap and to instill in them a sense of security and confidence, even though the minorities cannot per se be regarded as weaker sections or underprivileged sections. Now, 158 is the evocative passage that I want to read. The 1 billion population of India, consisting of 6 main ethnic groups, 52 major tribes, 6 major religions, 6,400 castes and subcastes, 18 major languages, and 1,600 minor languages and dialects. The essence of secularism can best be depicted if a relief map of India is made in mosaic, where the aforesaid 1 billion people are the small pieces of marble that go into the making of the map. Each person, whatever his, her language, caste, religion, has his or her individual identity, which has to be preserved, so that when pieced together, it goes to form a depiction with the different geographical features of India. These small pieces of marble in the form of human beings, which may be individually be dissimilar to each other, when placed together in a systematic manner, produce the beautiful map of India. Each piece, like a citizen of India, plays an important part in the making of the whole. The variations of the color as well as the different shades of the same color in a map are the result of these small pieces of different shades and colors. But even when one small piece of marble is removed, the whole map of India would be scarred and the beauty lost. Just over the page, my lord. Each of the people of India has an important place in the formation of a nation. Each piece has to retain its color. By itself, it may be an insignificant stone, but when placed in a proper manner, going into the making of a full picture of India in all its different colors and hues. A citizen of India stands in a similar position. The Constitution recognizes the differences amongst the people of India, but it gives equal importance to each of them, their differences notwithstanding, for only then can there be a unified secular nation. Recognizing the need for the preservation and retention of different pieces that go into the making of the nation, the Constitution, while maintaining inter alia the basic principles of equality, contain adequate provisions that ensure the preservation of these different pieces. I wanted to read this, my lord. It's a very evocative passage, my lord. Now, my lord,
yes,
your lordship will be dealing with pieces of marble, my lord. How you deal with it, my lord, will come later. Now, my lord, may I invite my lords and lord to my submissions,
yes.
which is in volume 1, page 195, PDF 195. I'm going to go at super speed, my lord, because there's a guillotine on my head now. Very sharp one, I might add. Now, my lord, I'll just take your lordship very quickly. Come to the 198, my lord, page, the external, your lordship's page. Skip all that, my lord, and come to page 200, which is PDF.
I'm not able to get. Which file are you?
Volume 1 of the written submissions, my lord.
There's a WC.
Yes,
Yes.
that
Yes.
is the submissions of all men.
Volume 2 is symbols, W is volume 1 is the rest.
Oh, I see.
I'm sorry, my lord.
190. Your PDF page 195.
Page 195, where it starts, my lord.
195 to 280.
There is an index which I won't trouble your lordships with, my lord.
This volume 2.
But I'll take volume 1.
Volume 1.
Volume 2 was Mr. Sybil's submission, which came, my lord, a few days late.
Article 7.
200 पे नहीं आ रहा है, वो 00 पे आ जाता है। नहीं, volume 1 पे है।
but at 200. Your lordships have it, Milord?
Yes. Yes.
I'm taking your lordships on PDF 200 in para 1.5, because all the other documents have been read. I'm not going to repeat them. The history has been shown to your lordships. But I made a point, my lord, about why the merger agreement was important and why 370 in one sense represents the standstill and merger agreements. I'm going to read this passage, my lord, from Premnath Kaul in para 1.5. Has your lordship got it?
Yes.
Referring to the past, my lord, thus there can be no doubt that this act of 1939 marked the second step taken by the Highness in associating his subjects with the administration of the state. It did not constitute even a partial surrender of his Highness of his sovereign rights in favor of the Rajya Sabha. Even after the instrument of accession, my lord, he had not given up his rights. That, your lordship, will come over the page. I can give the PDF numbers to this if your lordship wants, my lord, but it's in.
No, we've got it.
Now, my lord, dealing with after the instrument of
How
accession.
many judges was Premnath Kaul? 5.
No, it's. Yes, 5 judges. These are all constitution benches. Now, my lord, may I take your lordships to 1.7?
This is in relationship in regard to the relationship of these the Maharaja with the Praja Sabha.
This is Praja Sabha, my
Praja
lord.
Sabha.
I'm now building on that, my lord.
Yes.
Therefore, my lord, what actually 370 represents is two powerful democratic movements, my lord. One in the people of India, my lord, and the other, my lord, in the people of Kashmir, demanding of their Maharaja, which is eventually what he did. He gave a Praj Sabha, he wanted a national assembly, but he didn't agree to a constituent assembly, which came later, my lord. Now, my lord, 1.7. Maharaja Hari Singh continued to be the absolute monarch of the state, and in the eyes of international law, he might conceivably have claimed the status of a sovereign and independent state. Because all the instrument of accession did is put in these 4 conditions and said externally, my lord. That's why I made the distinction between external sovereignty and internal sovereignty.
This is with reference to date is 15th August 1947, not with reference to the,
I'm coming, my lord, to the instrument of accession, my lord, in 1.8.
that's 1.9.
That's right, my lord, that's the instrument of accession. Immediately after that comes 1.10. Thus, by the instrument of accession, the Maharaja took the very important step of recognizing the fact that his state was a part of the dominion of India. That's all that the instrument of accession represented. We can't say at that point that he had surrendered all his sovereignty. He had not, my lord. That process began partly politically because of the political movement and partly because of 370, my lord. Because that's where we see a coming together of the Constituent Assembly, the governor, the president, all that comes together because there was no merger or standstill agreement. Now, I won't read, my lord, the proclamation of the Maharaja, my lord, of 1948, where he talks of his Council of Ministers. I'll just come straight away, my lord, to what Sardar Patel said over the page in 1.13. In view of the special problems with which the government of Kashmir is faced, we have made a special provision for the continuance of the constitutional relationship of the state on the existing basis. And it's very important to understand what 370 really represented and what the instrument of accession really did. It bound itself to India, but the rest of the process of democratization, my lord, of adjustments, of sharing of power, was never done in the case of Jammu and Kashmir. Even in the white paper, my lord, on the states, there is one paragraph which says, we are not dealing with Jammu and Kashmir. Then, my lord, your lordships will just come to 1.21. This is on the 12th of November, pursuant to a resolution of the Constituent Assembly resolving to end hereditary rulership in the state, Yuvraj Karan Singh was elected to the post of so-and-so, and dynastic rule in J&K came to an end. Now, your lordships have already been shown how CO 48 emanated from the Assembly of Jammu and Kashmir, Constituent Assembly, and became part of our constitution. This part, my lord, of your lordships, I needn't give you the cross references, need I, my lord? PDF.
No, that's
Now, my lord, I'll skip the rest. 1.24, my lord, I've already read the second proviso to Article 3.
yes, we
So
saw.
I won't read it again, my lord. But I come, my lord, to page 11, 1.30. Before that, my lord, just
Dr. Dhawan, just
1.25.
one thing, just more for your juniors than for you. The dates which you have given in the written submissions, if anything is missing in Mr. Sibbal's list of dates, perhaps it might be good if we have it in one place. Likewise, when the respondents begin, it would be very nice if we have one consolidated list of dates so that we don't have to, sort of then
That's right.
shuffle between two or three
Showing
different.
Mr. Sibbal's list of dates in a separate font or separate color or something.
And
Well,
something
but
which you're adding, because I think we were reading Mr. Sibbal's list of dates, there's no innuendo in any of the lists. It's just state the date. So if you feel that, there's something missed out, then you can make track changes in that list of dates. So it'll be a little easier for us ultimately after the meeting, isn't it, Sandeep?
My lord, what I'm endeavoring to do, my lord, substance to the list of
All right,
dates.
fair
This is
enough.
what I'm trying to
Fair,
do.
fair enough. Then there's not.
Not just reading it as a list of dates.
Fair enough.
Now, 1.25, my lord. .25, my lord, on the 17th of October 1956, the Constitution of Jammu and Kashmir was adopted by the JK Assembly. All the details are given there, my lord.
Yes.
Now, my lord, this is a singular aspect of Indian federalism, to have a separate constitution for a state. For others, you gave autonomous regions, you bound them together, you expanded it. But this, can the JK Constitution of 1957 be wished away by an amendment to CO 272, 273 and Article 3? It simply can't, my lord. So one of the big losses is, where is it? It's like Macbeth, the Thane of Fife, he had a wife, where is she now? If JK had a constitution, where is it now? Has it been subsumed by 273? And when I go to 273, my lord, I'll deal with that. Now, my lord, I come to asymmetrical federalism at 1.30. Kindly change that to multi-symmetrical, as I've argued, my lord. Now, my lord, all those references are there. But, and of course, I've given your lordship a list, which I don't want, which is not repeated here. So I'll come straight away to 1.33. the importance of the Delhi decisions, my lord. I'll take up the second decision first. The Chief Justice, after reviewing the asymmetrical provisions described above in State of Delhi so-and-so in 2023, held that regard must be had to the principles of asymmetrical federalism embodied in the Indian Constitution, and that constitutional principle must be given substantive weight to this underlying principle. I'll read that paragraph. Actually, I should read it at the end, but I'll read it now. This variance in the constitutional treatment of union territories, as well as the absence of a homogeneous class, is not unique only to union territories. The Constitution is replete with instances of special arrangements being made to accommodate the specific regional needs of states in specific areas. Therefore, NCTT is not the first territory which has received special treatment through a constitutional provision, but it is another example in line with the practice of the Constitution and visiting arrangements which treat federal units differently from each other to account for their specific circumstances. For instance, Article 371 of the Constitution contains special provisions for certain areas of various states, as well as the entirety of some states. The marginal notes to these articles composed of rubric of 371 provide an overview of a number of states where arrangements in the nature of asymmetrical federalism are made in the spirit of accommodating the difference and specific requirements of regions across the nation. The next, my lord, line, para 41. I'm not taking your lordships to the PDS, my lord, because this is enough of what I want to refer to. The design of our Constitution is such that it accommodates the interests of different regions while providing a larger constitutional umbrella to different states and union territories. It preserves the local aspirations of different regions. Unity in diversity is not only used in common parlance, but is also embedded in our constitutional structure. Our interpretation of the Constitution must give substantive weight to the underlying principles. This is, my lord, how we approach the Constitution, as has been done otherwise also. Now, my lord, I add to this, my lord, the huge number of precedents, my lord, of what is called transformative constitutionalism. 1.36. The ultimate goal, that's from Navtej Singh Johar, of our magnificent Constitution is to make right the upheaval which existed in Indian society before the adopting of the Constitution. The court in so-and-so observed that the Indian Constitution is a great social document, almost revolutionary in its aim of transforming a medieval hierarchical society into a modern egalitarian democracy, and its provisions can only be comprehended only by a spacious social science approach, not a pedantic traditional legalism. The whole idea of having a constitution is to guide the nation towards a resplendent future. Therefore, the purpose of having a constitution is to transform the society for the better, and this objective is for a fundamental pillar of transformative constitutionalism. Then, my lord, the Chief Justice, as he then was, my lord, in the 219 decision, my lord, of the Delhi decision, the Constitution is a transformative document. The realization of this transformative potential rests ultimately in the ability to breathe life and meaning into its abstract concepts. For above all, the Constitution was not intended by its draft persons, by its draft persons to be a significant instrument of bringing about social change in a caste-based feudal society witnessed by centuries of oppression and discrimination against the marginalized. As our constitutional jurisprudence has evolved, the realization of the transformative potential of the Constitution has been founded on the evolution of equality away from its formal underpinnings to its substantial potential. My lord, I cite this for a reason, my lord. When this hearing began, my lord, it appeared to me that we were reading the Constitution as if it was a statute. For a long time, my lord, we were going to this word and this proviso and that proviso, my lord. That is not how constitutions were meant to be read or to be transformed. Then, my lord, if your lordship will come to this question 1.41, I won't read it, my lord, because constitutional morality is also mentioned, my lord, in various judgments of my lord, the Chief Justice, when you refer to Pratap Bhanu Mehta's contribution, etc., my lord. Now, my lord, straight of NCT versus Union of India, if the moral values of our constitution were not upheld at every stage, the text of the constitution may not be enough to protect its democratic values. In order to truly understand what constitutional morality reflects, it is necessary to answer what is that constitution trying to say and to identify the broadest possible range to fix the meaning of the text. Constitutional morality does not mean allegiance to the substantive provisions and principles of the Constitution. It signifies a constitutional culture which each individual in a democracy must imbibe. Pratap Bhanu Mehta identifies certain features of constitutional morality, chief amongst them being liberal values which govern the making of India's constitution, and created expectations from the polity. One of the essential features of constitutional morality, thus, is the ability and commitment to arrive at decisions on important issues consensually. It requires, despite all differences, we are part of a deliberative exercise. It is going to be my submission, my lord, that this deliberative exercise, my lord, has not taken place with the changes of the J&K Constitution. Now, Mr. Sibal, my lord, had a number of questions that were asked in Parliament till the last day. Your lordship has seen that. Are you changing 370? The answer was no, no, no. And suddenly, my lord, out of the blue, we entered into 5th August. This, my lord, consultation or concurrence, my lord, is fundamental to the manner in which we read constitutions and how each provision comes into place. Then, my lord, I will just read, my lord, the NCT decision. That's the earlier one, my lord. While interpreting the provisions of the Constitution, the safe and most sound approach for the Constitutional Court to adopt is to read the words of the Constitution in the light of the spirit of the Constitution, so that the quintessential democratic nature of our Constitution and the paradigm of representative participation by way of citizenry engagement are not annihilated. This court must adopt an interpretation which glorifies the democratic spirit of the Constitution. The Constitution has mandated a federal balance wherein the independence of a certain required degree is assured to the state governments. As opposed to centralism, a balanced federal structure mandates that the union does not usurp all the powers and the states enjoy freedom without any unsolicited interference from the central government with respect to matters while exclusively falling into its domain. So this is the approach, my lord, towards constitution to multi-symmetric federalism. Now, my lords, I will take your lordships straight away, my lord, to 370. I think at some stage a question fell from your lordships. Weren't any protests made before that, my lord? I just want to take your lordships to 2.15 at page 221 external. My lord, there is a literature that could fill a library on the protests over 370. And then, my lord, the State Autonomy Committee, my lord, read this out. And of course, it goes to a slightly further extreme, my lord. But this is, my lord, the constitutional understanding, which is not too dissimilar with other federations. I won't read it, my lord. I've just pointed it out to your lordships. Once again, my lord, I've reproduced here the debates. I'm not going to read those out, my lord. Iyengar's speech has been read out to your lordships, my lord, 2 or 3 times. It's just that on page 224, whatever I've highlighted in bold, again, the government of India have committed themselves to the people of Kashmir in certain respects. They've committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or to wish to go out of it. We are also committed to ascertaining the will of the people by means of plebiscite, provided that peaceful and normal conditions are restored. And the impartiality of the plebiscite could be guaranteed. We have also agreed that the will of the people through the instrument of the Constituent Assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. This is the commitment, my lord, that lies behind Article 370. Then, my lord, at the bottom of the page, till a Constituent Assembly comes into being, only an interim arrangement is possible, not an arrangement which could at once be brought in line with the arrangements that exist with other states. Now, if you remember the viewpoints I've mentioned, it's an inevitable conclusion that at the present we could establish an interim system is an attempt to establish such a system. Then, my lord, I will skip, my lord, other passages that have been read out, my lord, to your lordships. The JK Constituent Assembly, my lord, 11.21. I'm coming to page, external page 217. Sorry, 217. 227. Why is it? Sheikh Abdullah's speech has been read, but this is their understanding in the absence of a merger agreement. As I indicated earlier, the 370 is in the nature of establishing the relationships. And in that portion that I've highlighted, this arrangement involved a division of sovereignty, which is the normal feature of federation, beyond the powers transferred by it to the dominion. The state enjoyed complete residuary sovereignty, which is what is reflected in the JK Constitution. So, my lord, the instrument of accession says list 1, list 3, they have their place, but we have all the residuary powers. Therefore, control over the state lists, my lord, as far as they are concerned. Then, my lord, when the draft constitution, my lord, was introduced, I'm coming to, my lord, 11.25 at 231 and 232. Just at 232, my lord, just above 11.26. By this I mean that all these special constitutional privileges which our state enjoyed prior to 1953 are enjoyed by her even today. In other words, the state enjoys the same kind of autonomy which it stood prior to 1953. Therefore, to say the instrument of accession wiped things out, my lord, is simply not correct. Now, my lord, 11.28, I've already read it out to your lordships, my lord, because it imposes a limit. One question that was put, can 370 be amended or not amended? Is it there permanently? Mr. Sibal said that's not before your lordships, but at any rate, it may not have been a sufficient answer. There is a proviso, my lord, that was added by CO 48. CO 48 is a foundational document, my lord. And that is at 11.28, provided further that no such amendment shall have the effect in relation to the state of Jammu and Kashmir unless applied by the order of the President under clause 1 of 370. In other words, after you go through the amendment process. Now, my lords, can this proviso,
Somebody's cell phone triggered.
what has happened is, my lord, when the microphone was on, some things emerged there which I didn't want to emerge because I was talking to my colleagues. I hope they will be excised.
That's what I went to him and told him that your whispers are also being recorded.
My lord, we will deal with all that, my lord,
शाम को बोलो और निकालने.
with a pinch of salt, my lord.
But it's quite accurate. Huh?
I shudder to think, my lord, if this was the case when we were arguing Babri Masjid, what would come in the transcript? Such a huge amount of exchange took place, my lord. Now, my lords, Therefore, my lord, how do you amend the 370? You amend it through the 368 process. But there was in CO 48, my lord, a provision that you will then go to 370 and follow the procedure in 371. And that's very important, my lord. Your lordship asked, what was lost from the 4th of August? This is something that was lost. And they didn't even use the amendment power, which is the only power available to them, my lord, to delete 370, not the circuitous process that they used in 272 and 273.
Yes, Dr. Sir.
Now, my lords, on 235, 11.32 onwards, my lord, your lordship conferred, that took time as well. Happy though I am that your lordships did, my lord. My lord, I'm going to be super quick, my lord. Just give me that indulgence. Now, my lord, here are all the cases. Your lordship needs to go through Premnath call, which I've summarized, my lord, in 11.33. Because it actually explains what the situation was after 1950. When there was an instrument of accession but no merger agreement. On page 236, my lord, my submission, my lord, from Premnath Kaul is application of 370 of the Constitution to the state of JK also does not impact the plenary powers of the Maharaja. The form of the Constitution to be applied to JK was a matter left to be determined by the State Constituent Assembly, and until such decision was taken, the constitutional relationship between the Union and the states was governed by the terms of the IUA. So the internal, my lord, relationship had to still be determined under 370. Now, my lord, an argument has been made on the basis of Puran, Lakampal, etc. What is the meaning of modification? And they say it's very wide. But, my lord, your lordship has to read it in context. And that is when the matter was not referred to the 7-judge bench, my lord. Your lordships took the view that please read these decisions in context. Don't read them outside the context. Now, my lord, I'll come to 370, my lord. What I've done in the meanwhile, my lord, is done a short page and a half, my lord. But I'm not giving it now because your lordship may introduce the guillotine earlier. Now, my lord, kindly come to 370.
Does that begin at 239, Dr. Dhawan?
Sorry, my lord.
Is that? Oh, sorry. I thought you were referring to your submissions.
My lord, I'm not going to repeat what's in the submission.
All right.
I'm going to just, my lord, stress what is not in the submission,
Fair.
which I've stressed orally.
Fair. Yes, Doctor.
Now, my lord, we need not be troubled with the provisions at all, my lord. That has been the great, my lord, call. This is a temporary provision. It's temporary to the extent that 370 indicates. Therefore, my lord, in my personal view, my lord, 370 subclause 2 and 3, which deal with the Constituent Assembly, my lord, have become motives. They have invoked this, my lord, in CO 273. All of a sudden, a provision, my lord, which is constitutionally beyond the extension of the Assembly, has suddenly been used in CO 273. That, and I think it's CO 44, is it? 44 is the only time, my lord, 370 subclause 3 was used. In 1952 and now, my lord, in the year 2019. So, my lord, what remains, my lord, after the Constituent Assembly? In our submission, what remains is 370 subclause 1. Not to be read as a statute, but to be read in context. And what are the provisions here, my lord? I'm not going to read them out, it's been read ad nauseum, my lord. It says, follow the instrument of accession, my lord, as far as consultation is concerned. For the rest, there must be concurrence. And the same is true, my lord, of D, 371D. Those provisions, my lord, are governed by the two provisos. Which then talk of consultation and concurrence again. The reason why I said, my lord, that 370 could not be tinkered with during President's rule is because there is a mandatory requirement, as it was in Article 3. About consultation and concurrence. You can't say we wiped out the Constitution, we wiped out all the treaties, so that 370 is gone. Amend it, go through that particular process. But by this circuitous route, my lord, mandatory provisions which survive in 370 subclause 1 are violated. And they can't be done in President's rule for a very simple reason. Because it says the state government, my lord. Consultation with the government of the state is declared by the President to correspond in such matters. Other matters in such list with the concurrence of the government of the state. Of course, provision 1 in this article shall apply in relation to the state. And then, my lord, once again in D. Now, my lord, can we wish this away by some circuitous route? 370, by far from being a relic, my lord, is in fact what is there in the merger of agreement read with the instrument of accession. In fact, my lord, I say this is part and parcel, my lord, of the multiple federalism that exists. You can't use these provisions, my lord, without subjecting them to the discipline of Article 370. And that's what Damnu, my lord, Damnu, your lordship will get to, also says you can't do it. So, my lord, I come back to my broader proposition that while President's rule was in operation, you could not use Article 3 because you can't substitute like one legislature for another. And you can't, my lord, do away with 370 for a very simple reason that mandatory provisions of the Constitution do not say that Parliament can do this and the President can do this. It says it must be done by the government of JK, which is not, my lord, the ersatz government of JK, but in 272, it says with the Council of Ministers. And that is fundamental to the operation of any government. So you don't do it with the Council of Ministers. Can you do it simply, my lord, the way it was introduced in Parliament by Mr. Amit Shah? That you simply do it by saying, we're using 370 and this is how it's done. In President's rule, my lord, it cannot be done. There is no tearing hurry, my lord, in our Constitution to say that the amendment power can be used and abused whenever you want it to. Now show me the. My lord, I want to show quickly two decisions, my lord, on why the merger is separated from. It is in volume 6, my lord, of the cases. And the case is Pramod Chandra Dev. It's at page 1587. PDF. And I want PDF 144. The steps that were required. And I'm saying that this, in fact, is in a sense, my lord, the merger agreement is really what 370 is. Now, my lords, I take your lordships to page 1596.
Dr. Dhawan, which volume?
Sorry, my lord, volume 6. Cases, volume 6. Item number 10, page 1587. PDF. 135. It starts at 135, and I'm taking your lordship to 1596 at 144. My lord, this is in para 10 on page 1596, my lord, the bottom of the page, my lord. This was, my lord, some
What PDF page will that be actually?
144.
144.
It says of the instrument of accession, Lord, in the last 5 lines of page 1596. Does your lordship have it? This accession, that is, instrument of accession, did not affect the continuance of sovereignty of the rulers entering into the agreement, save as provided by or under the instrument of accession. So there was no external sovereignty was lost, my lord, but internal sovereignty, my lord, remained where it was. And then, my lord, going over the page at 1597, my lord, 4 lines from the top, the second step was the signing of what has been termed the standstill agreement, the form of which appears in the white paper. And the acceding state signed the standstill agreement which provided for the continuance in time of all subsisting agreements and administrative arrangements in the matters of common concern between the states and the Dominion of India. The first phase of the process of integration of the Indian states into the Indian Dominion was the accession of the states as aforesaid. The second phase followed on the merger of the states into the Dominion of India as a result of the merger agreement. Now, there was no merger agreement, my lord. So where was the merger agreement, my lord? Either we continue the sovereignty, it was said, my lord, in Premnath Call, or we say that this is the essential step by which, my lord, internal sovereignty and internal arrangements are worked out. Then it says, my lord, a little further down, but 4 lines below that, my lord, as a result of the merger agreement signed by the rulers of these states on or after 14th December, but before the 1st of January 48, the Dominion of India was vested with sovereign powers and the ex-rulers were left only with their private property and their annual privy purses. This was the effect of the merger agreement. And it's all there in the white paper of the states, my lord, which I don't want to go into. So where was this loss, this arrangement of internal sovereignty worked out? In Article 370, my lord. The only 2 other states were Hyderabad and Junagadh, my lord, they stand on a footing of their own. And that is why, my lord, I emphasize that 370 is the repository of the merger agreement read with the instrument of accession. In this very volume, my lord, I want to refer to one other which is the first Privy Persons case, my lord. It starts at
PDF?
PDF 390. And I want to take your lordship straight away.
And the instrument of.
Of course, the amendment came later in taking the Privy Persons Amendment power away.
Page 3.
So, my lord, we're still on volume 6, my lord, and I'm taking your lordship to PDF 457. Just one small paragraph. Paragraph 111 on page 1909. PDF 457.
Referring to paragraph 11, Mr. Howard?
May I read out, my lord? Para 1 and 111.
Yes.
The plea raised by the union must be considered in the light of these developments. The political developments in the history of negotiations and agreements were certainly not intended to be an exercise in futility. The argument that the parties to the instruments were entering into a solemn undertaking intended the arrangements to be temporary and likely to be set at naught by the unilateral act of the Union of India must be rejected. This is building on Mr. Sibbal's argument, my lord. A unilateral act, my lord, the assumption you don't take into account history. So the argument raised by the union that this is an exercise in futility going back, the response is the argument that the parties to the instruments were entering into solemn undertakings intending the arrangements to be temporary and liable to be set at naught by the unilateral act of the Union of India must be rejected. Submission, my lord, which I will hand over and go through it. One of my arguments, my lord, whether it is done by transformational morality, my lord, because of the antecedents, or whether it's done by basic structure, or which transformational morality, in my view, is a part. That 370 to that extent is part of the basic structure. As a substitute for the merger agreement, as an interpretation, my lord, just hand over that. $356, my lord. Where is it anyway? My lord, I'm coming back to volume 1 of the submissions. The PDF number is 267. My lord, I put in a table to show how President's rule has been exercised and Section 92 has been exercised. My lord, it is my respectful submission. They cannot be exercised in tandem. As it was, my lord, governor's rule had taken place and now President's rule was imposed. On that, my lord, if your lordships will see, I've given, my lord, all the cases that I want to cite. I won't bother your lordships with them. Except, my lord, page 276, which is PDF 276, 4.25.
I'm sorry, Mr. Nahal, what are you referring to?
Not my submission.
Your submission.
I'm now winding up, my lord.
Page number?
mercifully.
276.
276.
276.
An important aspect, my lord. Bomai, of course, is there. You can't remember that in Bomai, my lord, it was just the action of Presidents. 32 was not involved in the same extent. But I'm relying on 4.25, Rameshwar Prasad's case. Has your lordship got it, my lord?
Yes.
It is open to the court an exercise of judicial review to examine the question whether the governor's report is based on relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. This, my lord, is what your lordships have indicated on the extent of judicial review. Now, what has happened in this case, my lord, and your lordships, my lord, as a Nagaraj can lay down conditionalities for the exercise of 356. All the documents must be made publicly available and placed before Parliament. In this case, even the governor's report, my lord, was not placed before Parliament or before the court. So when your lordship, my lord, says 356 is justiciable, what are the contours of this justiciability? A full, frank, and complete disclosure to Parliament and to the people. Just to say that this is, I've received this message, there it is, and not even to place the report. That is why I say, my lord, the entire exercise of President's rule needs to be examined by your lordship in this case. Others will argue, my lord, more on this when their turn comes. Now, my lord, I'm going to give your lordships my summary, my lord. Give it to the other side. Because this, my lord, is the substance of what I've added to my written submission. May I read it out, my lord?
Yes.
Yes.
India has a multi-symmetrical constitution to be interpreted as transformational in nature. It's unique. And that is why your lordship insists on these transformations, despite the many amendments, despite the length. This is a multi-symmetrical constitution. My second submission, the instrument of accession represents, subject to conditions, the loss of external sovereignty. However, standstill and merger agreements finalizes the internal sovereignty arrangement. And that, my lord, is to be the internal sovereignty arrangement is to be found in 370. 370 is the result of a binding historical agreement. The instrument of accession deals inter alia with conditions of external sovereignty, but in the absence of standstill and merger agreements, 370 represents a substituted, constitutionally consecrated measure agreement for finalizing internal and external sovereignty, resulting in two interactive sui generis constitutions, unlike any other states. It is unique and part of the basic structure entrenched in democracy and federalism. For basic structure, my lord, read transformational constitutionalism. 371 alone survives, and 372 and 3 have exhausted their invocation. Why is this important, my lord? Because, my lord, after 1954, the first time 373 was used was in 273. The provision is gone, the Constituent Assembly is gone, and the substitution is for the Constituent Assembly, the legislature of the state. How can you resurrect, my lord, 370 subclause 3 all of a sudden, years later, after the assembly is over and there is a JK constitution? Now, my lord, as far as the width of power under 1D is there, my lord, is subject to constraints. I needn't say more than what has been said before. It's subject to its two provisos, and for the rest of the Constitution, consultation and concurrence. Now, my lord, Article 3, 4 and 370 contain mandatory requirements on information to be laid before the House and inter alia requiring concurrence and consultation. Unfortunately, the mandatory requirements of Article 3 for sending the bill to the legislature was suspended by the presidential proclamation of 19th December 2018, which is ultra vires and taints both the declaration and the extension of President's rule in 2018 and 2019. Then, my lord, on President's rule, the President's rule provisions of 356 and 392 and section 92 of the JK Constitution can not be imposed in tandem. 3 and 4 and 370 cannot be invoked during President's rule at all, since they require the existence of a legislature and state government, for which the President and Parliament cannot be constitutionally countermanded. Then President rule as required by S.R. Bomai and Rameshwar Prasad is justiciable, requiring objective basis, which includes the governor's report, and all material should be placed before the people and Parliament justifying itself.
Formulated it well. Sara unka jo. No. I was just telling my colleague that you have really summarized very precisely all that you have argued. We've taken down what you have argued, but now this formulates.
We read it out, Manoj.
Certainly.
And then I'll sit down. And that's a promise. Now, my lord, Article 370. So I've said all the materials, my lord. Article 370 can be amended, subject to the caveat in CO 48 that all amendments relating to JK must follow the procedure in Article 370 subclause 1. It is not enough in 273 says all treaties are out and the Constitution is gone. How can a constitution disappear like this, my lord? Many federations, my lord, have two state constitutions, and JK, because of its nature, my lord, did. Accordingly, 272 and 273 are invalid as being excessive, and the JK Reorganization Act 2019 under 3 and 4 as going beyond the mandatory provisions and in violation of the process of Article 3, wrongly suspended by the presidential notification of 19th December. Now, my lord, I ask, my lord, answering your lordship's question, what was lost in
Yes.
4th of August?
That's point 9.
Mr. Zafar Shah, my lord, will give your lordships a detailed account.
Itemized list.
This is my summary account. What was lost? The loss of statehood by degrading it to union territories. That was lost. Indirect abolishment of the JK Constitution. Loss of residuary power. Loss of territory contrary to the JK Constitution, Section 3. Section 4, sorry. Abolition of mandatory, informatory, concurrent, and consultation provisions. Conversion of statehood into union territories without adequate safeguards, especially for JK and Ladakh Constitution, without a proper amendment and consultative process and concurrent procedure of Article 370, for which CO 48 was added to 368. The right of permanent residence of JK on their right to property and to vote. Because 31, my lord, Article 31 was not suspended, only the later Article 31 remained. In the light of the above, it is pleaded, restore statehood to JK, permit the continuance of the JK Constitution, have immediate elections under the JK Constitution, abrogate President's rule. So this is what I have to say. I'm sorry I've stepped over my time.
Thank you, Dr. Dhawan. Thank you very much, Doctor. Yeah.
Allow me to begin with this, Lord, profound words of Justice Aaron Barak, Lord, the President of the Israeli Supreme Court. Lord, he was reported in Harvard Law Review as way back in 2002. Since, Lord, we are expounding Constitution, Lord, these are extremely apt words. And I quote him: the task of expounding a Constitution is crucially different from that of construing a statute. A constitution is drafted with an eye to the future. Its function is to provide a continuing framework for the legitimate exercise of governmental power. Now, Lord, 370 is perhaps the most brilliant, Lord, articulation of statesmanship on the part of the constitutional framers. You are at a time when the Lord calls for plebiscite in Kashmir are being raised. You are at a time when raiders are raiding the Lord in plain clothes and trying to take away. You are at a time when Maharaja is uncertain whether he wants to join the dominion of India or Pakistan. You are at a time when Lord India is just being born as a Lord dominion nation. At a time like that, Lord, it was a brilliant compromise that was arrived at, which, Lord, led to, Lord, producing this article, which persuaded the people of Jammu and Kashmir to accede to India. We gave them a promise. You cannot, Lord, breach that promise in the manner that you have done, or for that matter, at any point of time. And that's why, Lord, what Dr. Dhawan very rightly points out, that, Lord, ultimately, each, Lord, article of the Constitution, Lord, deals with this kind of diversity, which, Lord, if we were to start tinkering with, then, Lord, nothing will be left of the Constitution. So, Lord, your Lordships may have to consider, Lord, and my respectful submission, three, Lord, submissions. One, that Article 370 is a piece of, Lord, unusual, Lord, draftsmanship. It is temporary, but it is not temporary by a flux of time as most temporary statutes are. It is temporary by object, the purpose. Once that object is achieved, once that purpose is subserved, then, Lord, nothing remains for the president to exercise. So, Lord, it's going to be my respectful submission that 373, Lord, has served its purpose. The day Constituent Assembly of Jammu and Kashmir agreed that yes, Article 370 must remain on the Constitution of India, subject to following modification, and President accepted and issued that modification in, Lord, CO 44. That's the end of the story. Lord, your Lordships have taken the view right from federal court, and I will show, Lord, series of judgment, that temporary statutes, Lord, General Clauses Act does not apply. If that is so, then, Lord, the exercise is one-time exercise. You cannot exercise it again and again. It was never intended to be exercised again and again. Now, if it is not a continuing exercise on a demurrer, in my respectful submission, then, Lord, the only way Parliament could do it is by amending the Constitution under Article 368 and repealing Article 370, and in no other manner. And I will show, Lord, that's the view, Lord, 8 of your Lordships have taken in Berubari's case, where your Lordships, Lord, interpreted a treaty and said that you cannot do this unless you amend the Constitution. And lastly, it's going to be my respectful submission for your Lordship's kind acceptance that the exercise of powers by the President on 5th of August and 6th of August 2019, Lord, are nothing but fraud on the Constitution. As Dr. Dhawan rightly points out, there is nothing on record why a provision which has successfully survived from 25th October 1947 till 6th of August 2019 should have been repealed, as they claim, or should have been withdrawn. There was no material whatsoever. The only material with respects was that the ruling party in its manifesto in 2019 had said, we will abrogate Article 370. Your lordships in DC Wadhwa's case have said that you cannot exercise constitutional powers to achieve political ends. Lord, it's a classic case of fraud on constitution. So, Lord, you have a government in association with a local party in Jammu and Kashmir. It is working well. You suddenly withdraw the support from that government. Then you persuade the governor to issue president to issue a 356 order. Then you persuade president to issue a resolution of the assembly. Parliament then apparently takes control of legislative and executive functions, and then you say, now president will exercise all powers into one and pass orders under 370. What more classic example of abuse of power than this can be? As Chief Justice Polk said way back when the fight began with the king, that king can do everything except making a man a woman and a woman a man. Surely president could not have exercised these powers under 373, assuming himself to be everything. Has been pointed out at great pains and very brilliantly, that 356 is a temporary provision. Now, 356 being a temporary situation, can you take actions which are permanent or permanency? Or permanent in nature? Forget anything else. Because 356 itself says that everything that you have done in the interregnum will come to an end. And maximum period for which you can exercise 356 is 3 years. So, to do this, in my respectful submission, it really strikes at the very basic features of our constitution. Democracy, federalism, Government of India in their affidavit before your lordships categorically admits this, and this is very important, the counter, which I'll read at appropriate stage, that Constituent Assembly of J&K did not in any manner deviate from the provisions of the Constitution of India, which would be applicable to J&K. This is their profound statement. Then they try and they say that ultimately that what we have done is because of national interest. Nobody knows what this national interest is because it's not been defined in their counter affidavit. There was no material whatsoever. As I said, it has survived. Of course, there is insurgency. Nobody can deny that. But then we have insurgency in so many states in Northeast India. We had insurgency in Punjab for a long time. If we were to start not disintegrating states into union territories in this manner, no state will be safe in this under political class that we have today. Tomorrow it may so happen that my party cannot get elected in a state. I will disintegrate into union territories because there is law and order problem. This is something which your lordships will have to very seriously consider. It's not just one-time exercise. It has such broad ramifications for future of India, for the constitution of India, for federalism, for very existence. That it will really be giving now this kind of a power to a majoritarian government will be destructive of rule of law. It would be terribly destructive of rule of law. And I beseech your lordships, that's why in Coelho, your lordships have very beautifully put it, that constitutionalism demands that your lordship should oversee every act of the parliament and the executive. And the moment your lordships will find that there is infraction of constitution, your lordships will come down heavily on them. It's all right to create this atmosphere of fear all around. Nobody brought one thing, I must tell your lordships, very interesting, very few people, way back on 27th May 1949 in the Constituent Assembly, a debate was going on about bringing 4 representatives of J&K who had not been invited so far. Question was whether they should be nominated or not, because everybody felt that they should be present. So Mr. K.T. Shah, who was an advisor to government of Jammu and Kashmir and who had Professor K.T. Shah had worked there very extensively, he made this statement which was very interesting, which was perhaps quite inappropriate. He said, it has been the declaration of highest authority of India and also that of accession of the state made by the Maharaja, who was the complete constitutional head on the day that accession was agreed to, was subject to confirmation by result of plebiscite. Now please see Pandit Jawaharlal Nehru's retort to that. Jawaharlal Nehru retorts by saying this is absolutely incorrect, 100% incorrect. I am amazed, surprised and astounded that such a statement is made by Professor Shah. Why? Because Kashmir had certainly become part of India and it will always be a part of India. Nobody denies that. Article Section 3 of the Jammu and Kashmir Constitution itself provides that we are part and parcel of India. Question is that when you have now, as your lordships have very rightly questioned about sovereignty, you can acquire a new land by either accession or by cession or by occupation. In each of these cases, you can take away complete sovereignty, as my Lord the Chief Justice observed. But what happens in a situation like this, where you have agreed as a nation, as a dominion, as a state taking over that territory, that I take your territory subject to this condition. What happens then? There, Derubari says that you cannot now get out of those conditions. And the only way you can do it is by amending the Constitution of India. Now, you don't want to amend the Constitution of India because then you have to follow the procedure. You need 2/3 majority in both houses. You may even need to go to the legislatures of the state because you are taking away representation of the state in Lok Sabha and Rajya Sabha. So you will need 50% of the states to agree to that provision. So these are the safeguards. If these safeguards are thrown out of window in this light manner, who else can protect except your lordships? So it is very therefore important for us to understand that this is not just about Jammu and Kashmir. Jammu and Kashmir was, is and will always remain part of India. But the promise that India made to Jammu and Kashmir, the cession which came about on terms and conditions, how do you interpret those terms and conditions? So your lordships are called upon to expound this constitutional provision, which in my respectful submission is, and I must tell your lordships that Premnath, first, your lordship said that yes, we have to await the confirmation by the Constituent Assembly. I will show those passages. Then in Sampat Kumar, your lordship said, Constituent Assembly has given that assent. People have agreed to abide by this, and President has accepted that. So both ways your lordship's court in these two judgments will not give a complete finality to what is the eventuality under Article 370, sub-article 3. So, Lord, in my respectful submission, this calls for a very different kind of approach than what government of India would like your lordships to take. Lord, that's an extremely, I would say it's a narrower approach. That's not how constitutions are interpreted, Lord. They have to be, these are durable provisions. They must go through the test of times. If merely because something has happened or is happening in Jammu and Kashmir, you have to do this, then Lord, it may happen in another state and you might be called upon to do that again. So, Lord, the power cannot be exercised because of, Lord, certain situation prevailing at a particular point of time. Constitutional provisions can't be tinkered with in that fashion. So, how do you make them durable? You make them durable by really understanding. But the need of the hour was that we wanted Kashmir to get into us, Jammu and Kashmir. So, Lord, at that point of time, we were left with no option but to accept what they offered us. Otherwise, we were afraid Maharaja might run away to. There was one fear that he might go to Pakistan. He might join Pakistan. So, Lord, nobody knows what exactly was happening, but who were the people who really were aware? The constitutional framers. And Lord, Dr. Iyengar's exposition of 370 is really the complete answer. Although, Lord, I am conscious that Constituent Assembly debates may or may not be, Lord, relied upon as Lord, but it gives a complete answer to what government tells us on Lord 370. He also says that all that we need is the wishes of the people expressed through a Constituent Assembly. Once that wish is expressed, it's the end of the matter. He says that, and I'll read that two paragraphs of this. So, Lord, whichever way one looks at this Lord, provision, in my respectful submission, this Lord, controversy needs Lord, a very, very delicate Lord, approach from your lordships, so that Lord, we do not end up Lord, creating a situation. Lord, today, let us assume for the sake of argument that today this decision is in national interest. Let us assume, Lord, for the sake of argument. Tomorrow, some other political party in power with majority may try and take a decision which is not in national interest. You have to therefore Lord, lay down law which will stop all these exercises for all times to come. And that's where constitutionalism comes into play. And I beseech your lordships with all humility at my command that your lordships may therefore look at it this way. Now take therefore, Lord, in this regard, Lord, kindly turn straight away to Lord, one judgment of your Lord. I have a compilation of judgments which are Lord, new, but you can also, Prasanna, you can add them. Well, we can. It is already with Prasanna. I can add them with just Lord, in 1 second if your lordships permit. No?
This is part of the existing compilation now.
It's not with your lordships, it's with the learned court master, volume 30.
130 case law.
13. Case law
So
compilation.
what is volume 29? We stop at volume 28.
29 and 30 have not been allowed by the chiefs.
These are judgments only.
judgments are in the compilation?
Dr. Dawes is.
Mr. Dave,
Sorry, Mr. Dave,
No.
I'm sorry.
Many of them are, but 5 of them are not. Which, Lord, your Lordship knows, Lord, our research goes on all the time.
That's Mr. Dave, but at some point of time, you have to freeze it all, otherwise,
These are judgments. Your Lordship can't certainly stop us from
Why not?
fighting judgment.
But we had-
Submissions, yes, I agree. But
But
Lord,
even
we have-
judgments, should it not be frozen when you submit written
No,
the
it's not easy.
compilation?
It's not easy to do it. And let me tell your Lordship honestly, because this is a thinking process. We are constantly thinking and constantly rethinking and rethinking and rethinking.
I think in the.
Lord, to find 5 judgments, I have seen more than 500 judgments. I can assure your Lordship.
If we apply this principle to ourselves on the lighter side, then we'll keep on thinking, not produce any judgment, and keep on thinking only.
Lord,
All that will happen.
Lord, your Lordship, once the matter ends, certainly we'll be thinking many a times over.
Yes, but we see.
But at some time, we have to also say, all right,
So,
now,
Lord, that's.
this is the guillotine, now I'm not going to think anymore.
All right, when my arguments are beginning.
All right, but if so many of your judgments are repeated in the compilation already.
I am not repeating,
So
those
then
are
just-
there. Those
then
are there
five,
which
which
I
are
am
the
not.
5 judgments which are not in, then
Yes.
just the judge. we can give them.
Judgments which are already given, I am not.
You. Actually, the back office work has to be done before the argument.
Much before the arguments, otherwise it becomes
So
impossible.
the way the problem is, if you are a singular
Lord,
counsel arguing.
Lord, once the debate begins in the court, your Lordships put questions. So,
Mr.
Lord,
Dave, what happens is that's why if we don't do this, essentially difficult matters will never get argued because the whole purpose is to restrict time. If you don't restrict time, we cannot carve out time for big matters.
I have promised 1.5 to 2 hours, I'll finish it. I am not going to take
My
a
concern,
minute
Mr.
from-
Dave, if you were the only counsel, it doesn't really make so much of a difference. Because you added something, subtracted something. When the multiple counsels, 10 counsels, 12 counsels, each person starts doing it, where do we go? This is the concern only.
Lord,
It is
but
not that we wanted to shut
law
out. this-
declared by this court, my Lord, your Lordships would always like to see. It's law declared by your Lordship's court, my Lord.
No, but I mean, there has to be a certain procedure also and orderliness in making
Every
something.
year, SEC online creates some 19-20 volumes. This is another problem.
Well, I'm sure, Lord, when your Lordships directed us to give submissions, we never thought that, Lord, so far as judgments are concerned, because it's a constant research. Nobody can, Lord, do it at one go. You are trying to find out again and again and again answers. Questions fall from your Lordship's, Lord, bench. So, Lord, to that, your Lordship rightly asked about sovereignty.
Volume 20. 2 volumes, Ms. Dave.
I don't know, 29 is by.
29 is Mr. Nowadays. That has also not been allowed by the board.
This is the problem. How can we do this?
Then how many volumes will we have actually?
It is
We
endlessly-
should be actually having one volume now of case law.
28 is the-
My 28 was allowed already earlier, but 30 is not an additional one. How many judgments? 30. I have brought printed copies also, if your Lordships like.
So volume 30 is 5 judgments.
5.
'29 also has just case law, right?
Yes, yes, ma'am. There are no submissions. These are only judgments. 28, 29, 30 are case law compliance.
All right, you can.
Some,
No, my apologies for it, but Lord,
What sauce for the goose is not sauce for the gander. So you will not.
I'm sure, my lord, Mr. Mehta will definitely like to cite, my lord, new judgments to
I
counter
don't
us.
think so.
It is-
He's not saying that I'm going to cite it. Don't give him ideas.
Lord, his smile tells us otherwise, my lord.
My learned friend aside.
What is it that you want to cite? All right, Mr. Dave, let's quickly run through it. Give us, give us those, why don't you give us the soft copies? Huh?
It's in the drive.
यहाँ पर है। Judgments or
No, yes, my lord, I would like to.
fellowship charity? Is it that you want to, why don't you then give the judgments in 10 minutes that we have today? You can really give us the framework. What are the judgments you want to cite? What is the principle? Just formulate the principle.
As I said, my lord, the three points that I want to urge. One is that, my lord, 370 by itself, my lord, is a self-exhausting provision.
All right, then what are the judgments? Just tell us
My lord,
the citation.
I'll tell you, Lord, it's Dalmia
Volume
Dadri.
29 page,
My lord, 1959.
volume
SCR,
30, right? Volume
Yes.
30.
PDF,
Just give us the PDF page.
my lord, PDF page 16161,
No, it can't be 16161.
page 2. Volume 30, page 2. You proper page. You sit down and you.
Volume, what is the site? What is the name of
But
the
this
case?
is Dalmia Dadri Cement versus CIT. But this interpreted this very broad letter of accession and said that this is a treaty. And Lord,
Para?
yes, Lord, paragraph 3, 5, and 8, 8.2.
82.
Yes,
Why don't you read out the relevant part, Mr. Bell?
yes.
Let him read it out.
So, Lord,
Yes.
now, Lord, here, your Lordship say, and I what fell from the Honorable Chief Justice.
What did it
Lord.
interpret? Interpreted?
Sorry?
What did it interpret, you said?
Lord, interpreted the accession agreement and Lord held it to be a treaty and then said sovereignty should transfer.
Sovereignty transferred.
Yes. But Lord, in the subsequent case, Lord, in Berubari, which is already on record.
Now, Berubari, where will we get the site?
Yes, Lord, Berubari is at, Lord, I'll tell you, Lord.
Which case law compilation?
PDF page.
Of volume?
Yes, Lord, it is PDF page 13, CLCP 492.
No, what is the volume?
13, page 492.
Volume 30 or 13?
13,
Volume 13, page?
92. 492.
Let's
Now,
go.
Lord, this will have to be read in extenso because this is a brilliant, Lord, exposition of a treaty and why, my Lord, your Lordships held that you cannot get out of this treaty except by constitutional amendment. Give me the page when I actually interpret the result.
Volume 30.
Don't ask.
Volume 13?
I, your Lordship knows, my Lord, that Mrs. Dave had to assist me. Your caused embarrassment to your Lordships at that point of time. Lord, Lord, that's why I proudly call myself technologically
It's
challenged.
so simple, Mr. Dave. Just give it a try for one day and you'll never go back.
I try to encourage you on the lighter side by saying I had an equivalent mind block to it. And among the mind blocks I had, I used to tell the chief, see, don't deprive me the privilege of, after a miscellaneous matter, throwing the file down. That's the only privilege a judge has after a badly argued matter. But but in these kind of matters, I mean, having done it last time, I realized that the volumes become so many in In a small matter, it's fine, but in a bulky matter,
No,
it works better.
This is the thing.
It works better.
Now.
So we are encouraging you, Mr. Dave, that please get on board.
Well, I am giving your Lordship PDF pages.
But that is what your junior is relaying to you. You have to give it to us yourself.
I don't know, Lord. That word I don't take away, please from me.
Volume 13, page 492. Berubarian.
Yes, Madam. I turn to. In view of our conclusion. Yes. Lord. Lordship. What para 31? My lords have got it. May I read it, please? What then is the nature of the treaty making power of a sovereign state? That is the next problem with which we must consider before addressing ourselves to the questions referred to us for our opinion. As we have already pointed out, it is essential attribute of sovereignty that a sovereign state can acquire foreign territory and can, in case of necessity, cede a part of its territory in favor of a foreign state. And this can be done in exercise of its treaty-making power. Cession of a national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in fact. In all cases of cession, the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate within a certain period in favor of the inhabitants of a ceded territory as means of averting the charge that inhabitants are handed over to a new sovereign against their will. But, now see me not these words, and I place them for your lordship's acceptance. But though from the human point of view, great hardship is inevitably involved in cession of a territory by one country to the other, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to the limitations which the constitution of the state may either expressly or by necessary implication impose in that behalf. In other words, the question is to how treaties can be made by a sovereign state in regard to cession of national territory, and how treaties, when made, can be implemented would be governed by provisions in the constitution of the country. Stated broadly, treaty making power would have to be exercised in the manner contemplated by constitution and subject to limitations imposed by it. Whether the treaty made can be implemented by ordinary legislation or by constitutional amendment will naturally depend on the provisions of the constitution itself. We must therefore now turn to the aspect, that problem, and consider the position under our constitution. In dealing with this aspect, we are proceeding on the assumption that some legislation is necessary to implement the agreement in question. Then lordships may omit 5-7 lines and please come to the words unlike other federations.
But before that, something very interesting. The Attorney General appearing for the Union of India in that case argued that there is something called the basic structure.
Correct.
They see that the learned Attorney General asked us to bear in mind the special features of the basic structure of the Constitution
Correct.
in construing the relevant provisions of Article 3. He contends that the basic structure of the Constitution is the same as that of the Government of India Act 1935.
That's how, right, 60. 60, right?
Yes.
60. Mr. Setalva, he alone could do that. Now, please see, Lord. Unlike other federations, the federation embodied in the said act was not the result of a pact or union between separate independent communities of states who came together for certain purposes and surrendered a part of their sovereignty. The constituent units of federation were deliberately created, and it's significant that they, unlike the units of other federations, had no organic roots. Hence, in the Indian constitution, by contrast with other federal constitution, emphasis on preservation of the territorial integrity of constituent states is absent. Now, my lord, this is important. But now, my lord, kindly turn to paragraph 44 at page 515. How does it begin? Yes.
Just read the lower portion.
Yes.
Also.
Just read what, my lord?
The paragraph 32, the lower portion.
In fact, you can start reading
Yes.
from, in fact, it is well known, and then go to the end, as my learned brother says. In fact, it is well known. Last 10 lines. Is directly goes against you.
That as a result of States Reorganization Act in place of original 27 states and one area which were mentioned in Part D in first schedule to the Constitution, there are now only 14 states and 6 other areas which constitute Union territory as mentioned in first schedule. The changes thus made clearly illustrated the working of peculiar and striking feature of the Indian Constitution. There may be some force in this contention. It may therefore be assumed that in construing Article 3, we would take into account the fact that Constitution contemplated changes of territorial limits of the constituent states, and there was no guarantee about their territorial integrity. Undoubtedly. Question is, can they be turned into union territories? Of course, they can be changed territories. No difficulty. That's express provision. And note the word, if your lordships were to read the word union territory for every word state in Article 3B, then the result will be absolutely very, very unbelievable. So, although the explanation says that state includes union territory, But if you were to read it,
Mr. Dave, I didn't want to interrupt, but if it can be done for the state, why not for union territory until unless there's something you can make out otherwise, and when the explanation goes, explanation says state and union territories use interchange.
Lord, I must tell you, Lordships, I am not dealing with that part of the argument which has
That's
been
fine.
very
Then we-
beautifully
okay,
done
then we
by
come down.
my worthy predecessors. But my Lord, I must tell you, Lordships, that what is really worrying me is this. Your Lordships are right, it can be done. Question is that, my Lord, if it can be done in Jammu and Kashmir, why can't it be done in Gujarat? Why can't it be done in Maharashtra?
Okay.
So, my Lord,
Let's
that's
move further.
something
Let's-
which you
let's proceed.
have to bear in mind. It
Let's
can't
proceed
be
further.
done. Now, my Lord, please turn to para 44. Straight at page.
I15.
Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 of the Constitution for the purposes of implementing the agreement. It is considered by learned Attorney General that this conclusion must inevitably mean that the law necessary to implement the agreement has to be passed under Article 368. Then, my Lord, 368 is extracted, and then your Lordships may kindly turn to, my Lord, page 516, para 47. On the other hand, now, my Lord, this is very important. Just see, my Lord, how your Lordships were viewing, my Lord, democracy. On the other hand, it's to be passed under Article 368. It has to satisfy the requirements prescribed by the said article. The bill has to be passed in each house by a majority of the total membership of the house and by a majority of not less than 2/3 of the house present and voting. That is to say, it should obtain concurrence of a substantial section of the house, which may normally mean the consent of the major parties of the house.
All right, we'll come tomorrow.
So, Lord, look at it this way. Your Lordships not construe even majority, not to be major parties of the House,
Now,
meaning that you must carry everybody on board.
After this, we have Mr. Dwivedi will be arguing, or Mr. Nafik. Right, between the three of you, if you could please request that, could you apportion the time so that, by lunch tomorrow we have completed with Mr. Dave, Mr. Dwivedi and Mr.
Said 2 hours, but I'll finish in 1.5 hours.
If you that I whole day, you portion the subject, I have portion the subject. But I state your organization.
So David, could we do this? Maybe if we give an hour to Mr. David, 10:30 to 11:30 tomorrow, then Mr. Nafade about half an hour. Would that be all right? Would
Require at least an hour.
make it?
Each one of us have his own nuance. I will see that overlap is minimal, but some overlap is bound to be there, can't be here.
So decided not to faced with the situation with the not against the other.
What we were thinking was that by tomorrow, because tomorrow is Thursday we complete one side, so that then next week the other side can open. So
I'm told
Could
the
we-
Lordships are continuing on Friday also.
no, Friday is miscellaneous. So if you could, in the evening today, just as you step out of the court, Mr. Dave, Mr. Nafade, Mr. Dwivedi, and Mr. Siu Singh.
Friend here.
Mr. Gopal, I don't know, Gopal
No, I am-
is
I am also appearing in the
moving fall
matter.
behind many of the arguments which have preceded him. And then Dr. Menaka.
Virat, I am appearing in the matter. I am,
So, may I, the sixth of the Learned Council, if you could just meet for 5 minutes after we rise, between all of you, so that, we wrap up by tomorrow on this side.
My friend invites us to a coffee.
not possible.
Absolutely. Interveners may give us short one-page written submissions on both sides, so that, interveners can give us one-page written note on both sides. So we will not hear interveners on this side and interveners on this side. We'll have written notes of arguments, I think.
But I must point out on this side, except the government, rest are interveners. So they may be.
But then, my lord, we have, just as the petitioners challenge it, we also have an interest in seeing, my lord, that the.
All right, we'll see tomorrow. But what we'll do is, please do sit down tomorrow between yourselves.
Intelligence is required in a matter like this.
So Mr. Parekh is also there. So between yourselves, if you could just apportion time so that, we are not, we don't really err in the side of giving someone more than.
I think your lordships will have to give us Tuesday. Considering the amount of seriousness with which my distinguished friends, Lord, all of them have been.
All right. We'll give you up to Tuesday. But tomorrow now, tomorrow, if you could please do this, that you can give us now exactly how we'll finish our wrap up with by Tuesday.
Really kind of.
So just 5 minutes, if all of you sit down on this side after we rise, it'll help.
Absolutely.
Thank you. Certainly.
Deeply obliged.